First of all, welcome to the second in this fall's death penalty focus series of webinars about the death penalty. I'm Maddy deLone, and I'm the Interim Executive Director at Death Penalty Focus. Death Penalty Focus is a California-based nonprofit that has been committed to abolishing the death penalty in California and in other parts of the country and the world since 1988. It works in coalition with others in California to raise awareness about just how unfair, racist, and barbaric the death penalty is. For more information about Death Penalty Focus and to find out how you can be involved, please go to our website at deathpenaltyfocus.org. That it is written on the screen behind me. I'm deeply honored to be here with all of you who have tuned in today. Thank you for taking the time to be here with us for How We Decrease Death Row and Abolish the Death Penalty, a conversation with the California Committee on the Revision of the Penal Code. Special thanks to our co-sponsoring organizations. One second, and I will share the screen so you can see them. There they are. I hope. These are the organizations who've helped spread the word about this webinar and the rest of the series and do amazing work in this field and in related fields. We thank them. You can see who they are on the screen now and in the materials that we will send around after the webinar is over. Thanks also to the DPF Board Committee and to the staff who helped put this program together. Before we begin, I just want to go over a few technical details. By now, most of you know how to use Zoom, but for the purpose of this session, we would ask you to use the chat function, usually found at the bottom or the side of your screen. Please send questions to us that you have for the panelists, or you can let us know about any technical difficulties you're having. We'll be here for about an hour, and we'll try to wrap up a few minutes before the hour to give you time to get to wherever you're going next. I also want to mention that Mary Kate DeLuco is here with us on the screen, and she's about to go behind her name. She's here to help field questions and to answer questions that may come up while the program is going on. So thank you very much for being here. Today's program, titled How We Decrease Death Row and Abolish the Death Penalty, a conversation with the California Committee on the Revision of the Penal Code. Well, I can't imagine a better panel for this program. We're excited to have with us the chair of that committee, Mike Romano, Rick Owen, a staff attorney with the committee, and Natasha Minsker, a consultant to that committee. So get your questions ready. I'll introduce them briefly, and you can read their fuller bios in the materials on our website. Mike Romano is the director and founder of the Three Strikes and Justice Advocacy Project at Stanford Law School. Previously, he was director of the Stanford Criminal Defense Clinic. He currently teaches criminal justice policy and advanced criminal litigation at Stanford. In 2019, Governor Gavin Newsom appointed Mike as the chairperson of California's new Criminal Law and Policy Reform Committee, the California Committee on the Revision Code. Today. Rick Owen is a staff attorney for the committee. Before joining the committee, Rick spent 8 years at the Alameda County Public Defender's Office, where he represented hundreds of people accused of misdemeanor and felony offenses and was a supervisor for attorneys handling misdemeanor cases. Natasha Minsker is an attorney and consultant focusing on criminal justice and political advocacy, and is a consultant to the California Committee. Natasha spent 14 years at the ACLU, most recently serving as the director of the ACLU of California Center for Advocacy and Policy, and earlier in her time at the ACLU as the director of the ACLU of California's Death Penalty Policy Project. They are certainly three people expert on this issue and on this report. Today's session will provide some background on the committee, describe the basic findings of the committee that led to its ultimate recommendations that the death penalty be abolished in California. They will also describe and discuss some of the interim steps that can be taken until we achieve full abolition to reduce the size of California's death row. After presentations by our three panelists, which should last about half an hour, we will open up the questions. We will open up the floor to your questions. Again, please use the chat function to ask questions. Before I let them get started, really, I want to make a few comments to set the stage for today's presentation. For those of you listening who are not from California, it's worth knowing that California has the largest death row in the country and also in the Western Hemisphere, with almost 700 people on death row, including 675 men who are held at San Quentin Prison and 22 women held at Central California Women's Facility in Chalchuga. Florida, by comparison, the state with the second largest number of people on death row, has 343, about half of California, and Texas, third, has 205, less than a third. In fact, California has almost a third of the people in the United States on death row in California. In March of 2019, Governor Newsom declared moratorium on executions in California. That moratorium continues today. That does not mean the capital cases are not moving forward, however. They are. It simply means that people will not be executed by the state while the moratorium is in place. With that said, I'd now like to turn the program over to our panelists, and we'll start with Mike Romano.
All right. I just was trying to say thank you, Maddy, and to Death Penalty Focus in general, and really leading this fight against what we think is just a horrible and barbaric law. And while we're here to present the findings and recommendations from the Committee on the Penal Code, there's a lot of people behind the scenes who aren't here, staff of the committee and other members of the committee that we'll talk about a little bit. So with that, let's get to it, and we're really glad to be here. So just briefly about the committee, it was formed on one of the last things that Jerry Brown did as governor, and our statutory mandate is to simplify and rationalize the substance of criminal law and procedure in California, establish alternatives to incarceration, and improve the system of probation and parole. Obviously, the death penalty, we feel, falls squarely into the first two parts of our mandate, and there's really no area of law in California that needs more rationalization or simplification than death penalty law. The other members of the committee are mostly judges and academics. So Judge Henderson, Judge Peter Espinoza, who's a former head of the criminal courts in Los Angeles County, Carlos Moreno, who was Supreme Court Justice in California, and Professor Ochin at Loyola. In addition, there are two members from the committee who were appointed by their respective leadership in their houses, Alex Lee from the State Assembly and Nancy Skinner from the State Senate. Last year, we made a number of recommendations. We chose in our first year not to touch any area of law in California that would require a 2/3 vote of the legislature or voter initiatives, and that would include the death penalty, obviously. So we made recommendations outside of the death penalty and outside of other areas like 3 strikes and life without parole. And 7 of our recommendations were recently enacted into law. I won't go through them, but we were very proud that we've, I think, made a substantial accomplishments in our very first year. Again, thanks to incredible staff, Natasha and others who helped usher these bills through the legislature. When we decide to take on a subject, we usually hold public hearings on them, and as we did in this case, including public comment, we issue various research memoranda, and then the committee votes on a report, which we are about. So not only votes on recommendations, which we have voted to recommend the abolition of the death penalty, including some interim steps, which we'll talk about later. But we'll also publish a full report on why we reached that conclusion, including some, I think, some new data and research that I don't think has been published elsewhere. And probably tonight, correct me if I'm wrong, Rick, we will be presented here for the first time publicly. When we did have our hearing on the death penalty earlier this year, these were the folks who testified before the committee. As you can see, for those of you guys who are familiar with the death penalty, and especially in California or around the country, I think you can see that this was really an all-star lineup of experts, and we really learned a lot from each of them. So again, not only, very broadly, the mandate of the committee is to simplify and rationalize the penal code. When Governor Newsom swore us into office, he also really directed us to focus on areas of law where there was excessive punishment and racial bias. And there's no, again, I'm preaching literally to the choir here, but there's no more area of law and no more area of California law that is rife with excessive punishment and racial bias than the death penalty. As Maddy said, California is the largest death row in the country. There's almost 700 people currently on death row, and yet we've had 0 executions in the last 15 years. 233 people have had their sentences overturned on appeal or habeas or some other procedure. That's actually a majority of the cases that have reached full adjudication in the courts. So, I mean, that's just staggering that most of the cases that have gone through the courts all the way have been the death sentences have been overturned. And of course, it's incredibly expensive. $4 billion is estimated has been spent on administering death penalty in California since 1977. So I think that that's the end of my portion, and I'd like to hand it over to Rick Owen, who is a staff member from the committee and really was one of the main drafters of our report and recommendations.
Thanks, Mike. And thank you everyone for attending and having me on. I just want to start to share some of the factors that the committee considered in coming to its final recommendations to abolish the death penalty. California has had over 40 years of experience with the death penalty. And when the committee looked at that 40 years of experience, it concluded that the system is complicated, costly, that the death penalty is imposed arbitrarily in a discriminatory fashion, and that it's not rational, fair, or constitutional. This chart that I'm showing now just depicts the growth of California's death row over the years. And what we can see from it is that there was a steep rise in death sentences until the early 2000s, followed by a period of slower growth, and then finally a slight reduction in the last decade or so. But there's still, as Maddy mentioned, we lead the country in the number of death sentences imposed. This next chart is interesting in that it speaks to the general dysfunction of California's death penalty system. Wherever you fall, whatever side of the debate that you fall on, we can kind of glean from this chart that we have a system that is not working. The number of executions depicted in the dark blue, the number of initial death sentences depicted in dark blue compared to the number of death sentences is extremely low. And we see that most people sentenced to death actually die in prison while they're awaiting their possible execution. It's also notable that if we look over to 2020 and we see this yellow bar go way up, we see that there was a steep rise in non-execution deaths that year related to COVID. So these realities, the fact that there's way more death sentences than there are executions, has led a federal court judge to conclude that the death sentence in California has actually transformed into one of life in prison with the remote possibility of death. And that federal judge actually concluded that the death penalty as administered in California was unconstitutional. That decision was overturned on procedural grounds, but it's just notable to see that at the outset, wherever you fall on the debate, the system is not working as it's supposed to. Well, part of what the committee does when it begins to study a particular subject is to look at what's happening in other states and other jurisdictions. And we did that as well with the death penalty study. And we noted that there's been some significant national developments in recent years. We know that earlier this year, Virginia became the first Southern state to repeal the death penalty. And under President Joe Biden, the federal government has imposed a moratorium on executions. And so with that, today, 23 states do not have the death penalty. There are 3 states, including California and the federal government, that have moratoriums on executions. And so the result is that the majority of states in the United States do not have the death penalty in law or in practice. In addition to these recent developments, we noted that there have been other recent developments of note, including that in 2009, the American Law Institute voted to remove the death penalty from the Model Penal Code. This was a significant development because the Model Penal Code's death penalty statute was the one approved by the United States Supreme Court and was used as a model for many state laws. As has previously been mentioned, we noted that in California in 2019, Governor Newsom declared a moratorium. We also had an attorney general appointed this year who became yet another attorney general in the last, I think, 3 attorney generals who have voiced opposition to the death penalty. In addition to that, district attorneys in Los Angeles, San Francisco, and Santa Clara all declared that they will not seek the death penalty. And district attorneys in Contra Costa and San Joaquin counties have said that they think that the current death penalty scheme is unconstitutional. So today, the reality is that most Californians actually live in a county where the elected DA does not support the death penalty or believes that it's an unconstitutional law. And these are all developments that the committee considered when coming to its recommendations. I'm going to loop Natasha in because of her vast experience with death penalty law. She's going to give a brief description of the legal and historical background of California's death penalty.
Thanks, Rick. And actually, before I jump into that slide, I wanted to answer Andrea's question I saw in the Q&A. She asked, why is California's have the largest death row in the country? It's a great question. You know, in part, California is a large state, but our death row is much larger than places like Texas, Florida, and Pennsylvania, which also have large populations. And Andrea, your question gets somewhat at the answer, which is that district attorneys in California have in fact been more aggressive at seeking death sentences than have district attorneys in other counties. In fact, Riverside County, in one recent year, just the county of Riverside sent more people to death row than the entire state of Texas did in the same year. So California's prosecutors have been very aggressive at seeking death sentences, but not all of them. Really a handful of them, particularly California, like the nation, has a southern death penalty problem. It has predominantly been district attorneys in the southern part of the state, including the previous district attorney of Los Angeles. The other part of the equation is, of course, that we execute very few people in California even before the moratorium. So let me give you a brief history of California's death penalty. So the death penalty existed when California was made into a state, but then in 1972, the California Supreme Court found the death penalty unconstitutional under our state constitution. It's actually a beautiful opinion in which the court finds that the death penalty is inconsistent with the standards of human decency. And I recommend if you all want to enjoy a good court opinion, this is an excellent one to read. Unfortunately, that ruling lasted less than a year. California does what we do so well. There was an initiative, and that initiative reversed the ruling and in fact put in place a language in the Constitution that says the death penalty cannot be found inconsistent with the state constitution as a kind of per se matter. That only lasted a few months because the very same year the US Supreme Court ruled that the death penalty was unconstitutional as it was then applied in the entire country. And so we had a period of time where there was no death penalty in California. Unfortunately, the US Supreme Court left open the possibility for states to try again. The US Supreme Court said the death penalty is unconstitutional as you all are doing it right now, but maybe you can do better, go back and try again. And California was one of the states that put in place a new death penalty system. And eventually, after the US Supreme Court approved a death penalty statute from the state of Georgia, California modeled its new statute off of that state statute that had been approved by the US Supreme Court. So in 1977, the legislature adopted up a death penalty statute. Jerry Brown, in his first term as governor, very famously vetoed that bill. And it was one of the very few times that the legislature overrode the governor's veto and it became law. That was, in fact, a narrower version of the death penalty than what we live under today. And that is because in 1978, the Briggs Initiative was brought to the voters, vastly expanding our death penalty statute. The goal of the Briggs Initiative was to, quite literally, they say this in their materials, make the death penalty apply to every murder. And as a result, California has continued to have the death penalty statute that applies most broadly compared to any in the country. Just a quick review of the process, what makes someone eligible for the sentences of either life without parole or the death sentence are the existence of special circumstances. If you go to trial and a jury finds true the existence of a special circumstance, then the minimum sentence you can get is life without possibility of parole. The only other possible sentence is death. And we do our cases in two phases, as does most of the country, where first, guilt is decided, and then second, the penalty is decided, whether it should be death or life without parole. And so often, if you get the question, why is the death penalty so expensive? It starts with the very beginning. It requires 2 trials, not 1. And of course, there's much more that goes into the process than that. California's post-conviction review process is particularly lengthy. It revolves at least 3 or 4, a minimum of 3, usually more layers of review as cases move through first state court review and then federal review before eventually having an opportunity to go to the US Supreme Court. And we currently have no functional method of execution. So the reason executions have been on hold for now 15 years, almost 16 years, is because of legal challenges to the lethal injection process, which resulted in what we called the court-imposed moratorium on executions prior to the governor-imposed moratorium that went in place about 2.5 years ago. So California's death penalty applies to almost any murder. 95% of potential murders, murders that occur, are potentially death penalty cases. The theme of this slide, legal problems with California's death penalty. So as part of the committee's work, we looked at what are the unique issues with California's death penalty from a legal perspective. As Mike Romano said, one of the mandates of the committee is to rationalize the law and to identify legal problems with statutes in California. So California's death penalty has unique issues and unique defects, reasons that I personally believe make it unconstitutional, but our California Supreme Court has not gotten there yet. Certainly the US Supreme Court may not get there for a while. So one of the legal defects is the overbreadth of our statute, the failure to narrow who is eligible for death. Back in 1972, when the Supreme Court said, the way you all are doing the death penalty right now doesn't work for us, the main reason was because it was scattershot. Anybody could be sentenced to death, and when anybody can be sentenced to death, then unlawful characteristics like racial bias, geography, wealth, determine who does get sentenced to death. And so the Supreme Court has this principle that in order to ensure that only, quote, only the people who deserve the death penalty get the death penalty, the statute should be narrowly drawn. And California's death penalty statute fails under that test. We have problems with the way we instruct jurors. And this issue was recently at the California Supreme Court and unfortunately rejected. So as you know, it's a basic principle of American law that we should have unanimity of our jurors and things should be proven beyond a reasonable doubt. Those basic principles don't apply in the context of whether someone should be sentenced to death. So the prosecution doesn't have to prove that death is the appropriate sentence beyond a reasonable doubt. And the jurors don't have to agree on the reasons why they are voting in favor of death. So really fundamental principles of due process that just go out the window when it comes to California's death penalty, and not the case in most other states where they have the death penalty still. As Rick mentioned, the delays in California's death penalty process have been noted by the courts as a fundamental legal failing that have risen to the point at which our death penalty statute as applied in California is unconstitutional. because it no longer serves any legitimate penological purpose. And that's a lot of fancy words, but basically, from a legal perspective, if you're going to have a penal code statute and you're going to have a sentence, it needs to serve a legitimate penological purpose. And the courts, one federal judge has said, California, because our death penalty process for review is so cumbersome and so delayed, we no longer meet that minimum requirement for what constitutes a legitimate law. And then finally, disproportionate sentences. So another core fundamental concept of due process is that we should have proportionality in sentencing, that people who commit similar crimes should get similar sentences, and people who commit different crimes should get different sentences. We don't apply that principle in examining death sentences in California. And so we have somebody on death row right now. He was literally your driver in a robbery, bank robbery gone bad. The two people who went inside the facility and shot and killed someone, those two people are now home. They got sentences of either life or life without parole. Life without parole was commuted to life. They've both been released and are back home. And the person who was in the car, didn't kill anyone, sits on death row. So that's the problem with lack of proportionality review. So I believe all of these things make California's death penalty overwhelmingly unconstitutional, but no one's given me a black robe yet.
Thanks, Natasha.
Thank you.
So turning to the racial bias, which is one of the most important factors that the committee considered in coming to its determination to recommend that the death penalty be abolished in the state. We know that California, like the rest of the United States, has a deeply, deeply troubling history of racial violence against people of color. And I was very interested to learn in researching capital punishment in California that California has a history of lynching that's similar to that of southern states in the South. And we have a whole section in our report that discusses the history of lynching in California, noting that over 350 people were lynched in the state and how that practice shaped views of capital punishment and our current capital punishment system. But in addition to this troubling history of violence, the committee noted several studies, current studies, that have focused on capital sentencing in California and found racial disparities in sentencing. Particularly, we found that there's several studies finding that the race of the victim will impact who is sentenced to death in the state. And there have been several studies conducted focusing on capital sentencing in California, and they've been conducted in different time periods, and they've used different research designs, but the results have been consistent, and they've all found that people accused of killing white people are more likely to be charged with a special circumstance that leads to a death sentence. But not only are they more likely to be charged with a special circumstance, and as Natasha mentioned, if you are convicted of a special circumstance murder, you're either going to get a life without parole sentence or a death sentence. But in addition to being charged with a special circumstance, they're more likely to be sentenced to death when a person kills a white victim. One of our committee panelists, Stephen Schatz, professor at University of San Francisco Law School and an expert on death sentencing in California, one of the authors of one of these studies actually commented to the committee that the results of these several research findings deliver a clear message that in California, white lives matter, and Black lives and Latinx lives not so much, and that white lives matter the most when the person who took the white life is a Black person. And that was something that was really impactful for the committee to hear. In addition to the data on race of victim disparities, there's current data that reveals that race plays a role in death penalty administration in California. Currently, 68% of people on death row are people of color, despite accounting for only 6.5% of California's population. Over a third of people on death row in the state are Black. More recent numbers are equally as concerning. Latinx people accounted for less than half of homicide arrests in the state between 2010 and 2020, but all 8 people sentenced to death in the state in 2018 and 2019 were Latinx. And in 2020, 3 of the 5 people sentenced to death in California were Latinx. And racial demographics of newer death sentences show a troubling trend. So if we look at death sentences imposed since 2010, the ratio of people of color sentenced to death has only increased. So since 2010, 72% of people sentenced to death have been people of color. We were also able to look into the data by county and look at the demographics of new death sentences by individual county. And focusing on the top 5 counties with the most new death sentences between 2010 and 2020, there are again some very troubling statistics. Starting with Riverside County, we saw that 86% of people sentenced to death in that county in that time period were people of color. And while Black people made up only 7% of the county population during this time, they accounted for 26% of the new death sentences. In Los Angeles County in this time frame, 95% of people sentenced to death were people of color. Black people only made up 9% of the county population during this time, but accounted for 45% of death sentences. In San Bernardino County, 50% of people sentenced to death were people of color. And Black people made up only 9% of the county population during this time, but accounted for 38% of the new death sentences. In Orange County, 77% of people sentenced to death were people of color. While Black people made up only 2% of the county population during this time, they accounted for 31% of new death sentences. And finally, in Kern County, 63% of people sentenced to death were people of color. Black people made up 6% of the county population during this time and accounted for 25% of new death sentences. And we also were able to look into counties that during this time period from 2010 to 2020, there were 20 counties that imposed a new death sentence. And in over half of these counties, they only had 1 or 2 new death sentences, but there were really concerning disparities for this population too. So for instance, in Alameda County, that county only sentenced 3 people to death, but all 3 were Black. Kings County sentenced 3 people to death, and all 3 were Latinx. Tulare County sentenced 3 people to death, and 2 were Latinx and 1 was Black. So new death sentences have been even more troubling in terms of racial demographics. In addition to the racial bias that we saw with death penalty sentencing, we saw that their geographic bias also determines who was sentenced to death in California. I think, as Natasha mentioned earlier, most death judgments in California are imposed in just a handful of California's 58 counties. And from 2015 to 2020, only 6 counties in California were responsible for 89% of death sentences in the state. And only 2 counties, Los Angeles and Riverside, imposed 61% of all death sentences in California during this time. Death sentences imposed in 5 counties account for 64% of all people currently on death row, despite comprising less than half of the California's population. And Natasha mentioned Riverside County earlier, and indeed, Riverside County has become a national outlier. In 2015, Riverside County sentenced more people to death than every other state in the country, except for Florida and California itself. And in 2017, 3 counties across the nation accounted for 31% of new death sentences in the entire United States. Riverside County was one of them. In 2020, Riverside County was responsible for 3 of 5 death sentences in California. One of the things we examined when we looked at geographic bias was whether it could be explained by homicide rates in those counties. Maybe counties that were experiencing heightened homicide rates were using the death penalty more. But when we looked at this data, we saw that counties that used the death penalty more often compared to counties that used it less, in both of those counties, the homicide rates fell around similar rates. So essentially it couldn't be explained, the death penalty usage couldn't be explained by homicide rates in those counties. Another troubling factor that led to the committee's recommendations is that California has sentenced young people and people with severe mental illness to death. As Natasha mentioned, our Supreme Court has held that the death penalty is supposed to be reserved for people who are extremely culpable and who are, quote unquote, most deserving of this penalty. One group of people that the Supreme Court has categorically excluded from death is people who have intellectual disabilities. Another is people who were under the age of 18 at the time that they committed the offense. Despite these rulings, many people are in California's death row that have intellectual disabilities. And in California, 45% of people on death row, or 316 people, were 25 years of age or younger at the time of their offense. 166 people were 21 years of age or younger, and 42 people were only 18 years old. And when we looked at the racial disparities for this group of young people, we saw that the racial disparities were even more pronounced. So while 68% of all people on death row are people of color, the percentage jumps to 77% for people who are 25 years of age or younger at the time of their offense. And if we look at just people who were 18 or younger at the who were 18 at the time of their offense, we see that 86% were people of color. So in addition to the racial geographic bias and the issues with people who are mentally ill and young people, we also noted that there are extreme costs and dysfunction with California's death penalty scheme. The state spends $150 million per year on its death penalty system. As we noted earlier, $4 billion since 1978. Because of the multiple phases of trial, among other things, the death penalty adds between $500,000 to $1.2 million to the cost of a murder trial, and post-conviction review takes up past 30 years. And even with these costs, the state is not spending enough money. People sentenced to death routinely wait decades to be assigned post-conviction lawyers. And when Governor Newsom initiated the death penalty moratorium, he highlighted that capital sentences in California are unjustly, unfairly applied to people of color who could not afford legal representation. And more than half of the 70 reversals of California death sentences by federal courts occurred on grounds that trial counsel provided ineffective representation. And in most of those cases, it was because the trial counsel failed to investigate mitigating evidence. So with all of the money California spends on death sentencing, it's still not spending enough money. People still aren't getting adequate legal representation. And that burden falls unfairly on people of color and people who can't afford adequate legal representation. So those were some of the factors that the committee considered in coming to its final recommendations. The further description of all of them can be found in our report, which will be published any day now. I'm going to bring Mike back in to describe all of the committee's recommendations surrounding the death penalty.
Thanks, Rick and Natasha. I'm just going to go through these quickly. These are the formal recommendations of the committee. And like I said, and Rick alluded to, we'll publish a report soon, hopefully, maybe even next week, giving all the data that Rick just presented. So, and then we'll open up for questions, right, Maddy? Yeah, all right. So most importantly, there's a unanimous decision of the committee to recommend that California abolish the death penalty. Of course, we recognize that that requires a new ballot measure, which could not be at the earliest time be until 2022, but it's unlikely to be on the ballot even then. But in the interim, we think that there's some steps that California can and should take to reduce the number of people on death row. The first is that the governor can and should award clemency to commute death sentences to people on death row. The state and the attorney general can settle pending legal challenges to current pending death sentences. And that is in the hundreds and hundreds of people who are current cases pending. Sentences can also be recalled under Penal Code 1170 by either the Department of Corrections or independent prosecutors in the various states. And I believe that's already ongoing in Los Angeles County. District Attorney has vowed there to recall over 200 death sentences from Los Angeles County. The legislature can limit the number of felony murder special circumstances. We'd like to also restore judicial discretion to dismiss special circumstances in cases. So it's not a mandatory life choice between life without parole and the death penalty. In 2020, the legislature passed the Racial Justice Act, but it applied prospectively only. We believe if it was applied retroactively, it would probably have an important impact on death penalty administration in California. And then finally, there are a number of people who are on death row currently today who are permanent, who courts have ruled and CDCR has acknowledged are permanently mentally incompetent to be executed. Those folks and people should be removed from death row immediately. There's no reason that they should be on death row. So those are the recommendations from the committee. As I said, we'll be publishing a formal report soon, and I look forward to hearing from you all. And thanks again for having us.
I think Natasha is going. I think Natasha, you're going to give people a few ideas about what to do, and we'll do that quickly, and we'll open it up to questions. I think there've been a couple of questions though about what is a special circumstance or special circumstances, and I wonder if one of you could answer that because it comes up sort of repeatedly, I think, again in the recommendations.
Yeah, so the special circumstances are the part of our death penalty statute that make someone eligible for death. There are currently 32 special circumstances, so they're not very special, we like to say. And that's what makes California's death penalty statute so broad. There are so many different factors that make someone eligible for death. Some of them are things that you would expect, like if you are charged with a murder and you have a prior murder conviction. And things like if you if you kill more than one person at a time. But they also are broad enough to include the getaway driver that I described. So one of the biggest problems is that our felony murder special circumstance applies in situations where they themselves didn't personally kill anyone and they didn't intend for anyone to die. So with this wide number of special circumstances that apply in so many different areas, we have a situation where people are on death row in California who didn't kill anyone and didn't intend for anyone to die, up to then the more typical situations that you wouldn't be surprised to find out are death sentence cases. Mike, did you want to add to that?
No, that was excellent.
All right, I'm going to just quickly touch on what can we do now. I call this how to end the death penalty in California without repealing the death penalty in 3 easy steps. So we can support legislation to get people off death row and reduce new death sentences. We can support DAs who do not seek the death penalty, and we can advocate for change for those who do. And very important, we can pressure the Attorney General to change their approach on the death penalty. Let's look at legislation. So 2 of the committee recommendations are in bill form now and are moving through the legislature. So this is a great opportunity for everyone on this webinar to get involved. AB 256 by Assemblymember Kalra is the California Racial Justice Act for All. This bill will make the Racial Justice Act retroactive, which would allow everyone in prison, and for our purposes, particularly anyone on death row, to challenge racial bias in their case, including racial disparities in outcome. Meaning that if their county, let's say Los Angeles, if it's more likely that someone will be sentenced to death just because they are Black or just because they killed a white person, that is a basis for challenging their death sentence under the Racial Justice Act. So AB 256 will make it retroactive and help people currently on death row. SB 300 by Senator Cortese, the Sentencing Reform Act of 2021, it will address 2 of the recommendations of the committee. First, it would give back to judges the discretion to dismiss the special circumstance. That means that it would give back to judges the ability to sentence someone to life in prison with the possibility of parole in any case. Judges would never be forced to sentence someone to death or life without parole. They would always have the option of giving someone a parole eligible sentence. The second thing that SB 300 does is address this overbreadth, the extreme way our felony murder special circumstance is written. And it would say that you can't be sentenced to death if you personally didn't kill anyone and didn't intend for anyone to die, by limiting and scaling back the felony murder special circumstance. Those two bills are moving right now in the legislature, and so you can get involved now and when the legislature is back in January. And you can also support other bills that are going to expand opportunities for resentencing and address the power dynamics at trial to make it more likely that people get a quality defense at trial and never end up on death row. So it's great to stay in touch with organizations like Death Penalty Focus and the other groups that sponsored this event so you can hear updates for other bills to get involved in. This is an example of some of the advocacy we've been doing around AB 256, the Racial Justice Act for All, that lifts up the recommendations of the committee and specifically links the goal of abolishing the death penalty with the goal of confronting racism and ending racial bias in our criminal justice system. So one of the ways you can get involved right now, you can do this right now. You can go on Twitter while we're talking and say, pass the Racial Justice Act for All. If you search hashtag AB 256, you'll come up with great examples of social media, and you can help promote the message online. That is the easiest way you can get involved. If you want to do more, you can come to our lobby day. So this is when we launched the original Racial Justice Act in March, I think it was March 11th in 2020, which happened to be the day that the World Health Organization declared a global pandemic. Didn't know that when we picked the date out, but we've made it through and we are now planning another in-person lobby day, hopefully in January, to push these two bills that we're talking about, AB 256 and SB 300. This, of course, is the great public defender of Alameda County, Brendan Woods. What else can you do? DA strategies. So we have 4 elected district attorneys in California who publicly oppose the death penalty. And not just that, they're not just publicly opposing on personal grounds. They have said in court that the death penalty is applied in an unconstitutional manner. They said that in a brief filed in the California Supreme Court. So we can support these elected district attorneys, some of whom are under fire, and need to know that the public appreciates and supports them for their position on the death penalty. We can also urge these district attorneys to go further by doing things like settling death penalty cases and resentencing. And then while we've got 4 district attorneys that are publicly on our side, there are more district attorneys that out there in California, specifically 54, that we need to move. Some of those district attorneys actually personally oppose the death penalty, but they're quiet about it. So, we can get those folks to make their positions known publicly, and we can get other DAs to change their positions. The Anti-Death Penalty Coalition that I'm active in statewide, we're particularly targeting the district attorney of San Mateo County, for example. He is somebody who has traditionally been in favor of the death penalty, and we are targeting him to try and get him to reevaluate and change his position, as some district attorneys have done. And if that doesn't work, then we can vote them out of office. Next year, in 2022, 56 district attorneys are up for election. So if you live anywhere in California, except for San Francisco and Los Angeles, you have an opportunity to vote for a new district attorney, and you can make sure that the people in your community know this is something they should be voting on, whether the DA supports or opposes the death penalty. Another important person we can be putting pressure on is the new Attorney General, Assemblymember, or now Attorney General Rob Bonta. So the Rob Bonta and the AG have a lot of power that they are currently not using. We can urge him to settle death penalty cases when there's evidence of legal error, and we can urge them to reevaluate the positions they're taking in court right now. As Rick said, the majority of death penalty cases in California, when they actually get a final decision, most are reversed. And that's after decades of the Attorney General's office fighting to keep those death sentences in place. So that means, as one exoneree told me about the prosecutor in his case, they're doing their job too well. right? When you are fighting to keep innocent people in prison and you're fighting to keep death sentences in place despite legal error, you are doing your job too well as a prosecutor. You are not doing it in the way an ethical prosecutor should. And so the AG should be reevaluating the positions they're taking in these cases, because it's the right thing to do, and also because they are losing after decades of litigation. And the Attorney General can also take the position that 4 elected district attorneys have done and recognize that California's death penalty is constitutionally flawed and should be found unconstitutional. So I'm going to stop there and turn it over to Maddy for questions.
Okay, there are a lot of great questions, and let's try to get to them. We have about 7 minutes. So there have been a couple of questions about a legislatively referred ballot initiative or an initiative at all. Mike said there's a possibility you could do one in 2022, but others have said not likely to work. Can somebody talk about both the initiative, when there might be time for one, and what about a legislatively directed initiative?
Natasha, you want to handle that?
Sure. So it's actually late in the legislative process to try and qualify an initiative for the ballot through legislative referral. That is something that would have needed to start a year before. And so really time-wise, we don't have the ability to do that now. The only other way to get a ballot initiative in front of the voters is by gathering signatures, which currently costs about $10 million. And that's just to qualify the initiative. After that, you need to have at least $20 million to actually run the campaign. And so California, we have done 2 initiatives seeking to repeal, and we have narrowly lost both times. Myself and most people I know who have worked on this issue for a long time feel that we should not go back to the voters until we're fairly confident that the outcome is going to be different, and until we have the many millions of dollars needed to run a winning campaign. And we're just not there yet on either of those measures.
Okay. Proposition 66 suggested it would speed up executions and make the system more fair. What happened?
I think that's one of the great findings of the committee report, is that it has failed. I don't know, Mike, if you want to say a little bit more about that.
No, I'm just almost the opposite has happened since certainly that was the intent of Prop 66, and it has almost gotten worse since its enactment. The Supreme Court has even ruled that the timelines that were supposedly imposed by Proposition 66 in terms of administering the death penalty were not really mandatory, but merely advisory. So they're not really going to abide by them. And there just aren't enough lawyers in courts and willing to take on these cases. So actually the processes that were established by Proposition 66, which really were intended to speed them up, have, if anything, slowed them down, definitely have not sped anything up, and have been a failure, as Natasha said.
Okay. Several questions about the concern around life without the possibility of parole being an alternative to the death penalty, or, and where are we on that? And has the committee thought about life without parole?
Yes, we have. And of course, it's a difficult subject that's wrapped up with the death penalty and wrapped up with death penalty politics. However, the committee, we try to make recommendations that are politically realistic, but we try to be as independent from politics as possible and make strong policy recommendations. And we've also voted in a separate report that will be forthcoming to end the practice, or virtually end the practice, of sentences of life without parole. So we realize that those 2 issues can be in political tension, but we still believe that both practices should be repealed in California.
Yeah, and then if I can jump in on, go ahead, Rick.
Oh, I'm sorry. I was just going to add that many of the same issues that we identify with the racial and geographic bias, with the over inclusiveness of the special circumstances statute, with issues with young people and racial disparities being even more pronounced in that population. Those issues that we saw and were very troubled by in the death penalty context, they certainly apply equally as well in the LWOP context. The committee did review LWOP sentences this year. We studied empirical research on LWOP sentences, and I see there's a question about public safety in the chat, and we found that empirical research suggests that long sentences generally do not increase public safety, and specifically life without parole sentences are no more, don't make the community any more safer than life with parole sentences. So they're not effective public safety tools either.
Excellent points, Rick. I was just going to add that the chat raises, I think the tensions here, that the problems with life without parole are almost identical to the problems with the death penalty. There's growing concern in the criminal justice reform movement, a strong belief among many that life without parole should also be replaced, that everyone should have an opportunity to show to the parole board that they're ready to go home. And here we are in California with the very high hurdle of trying to repeal the death penalty through voter initiative, which means we have an emotional conversation with voters on a very challenging issue, and trying to persuade them to vote for repeal of the death penalty requires that we make them feel safe. And so it's a very challenging needle to thread, and how we stay true to our values and recognizing that the reasons we are opposed to the death penalty apply almost equally to life without parole. And how do we find a way to communicate to voters that we can and should get rid of the death penalty, and where does life without parole fall in that? That is an ongoing conversation that we need to have as a community.
Okay, there are many other questions, and I'm afraid we're not going to get to them all. We'll read through them, and if there are questions that can be easily answered, we'll try to get answers to you. But I think in order to be fair to you all and our panelists with your time, I'm going to stop it now. Thank you very, very much to all of you. And Natasha talked about, the beautiful Supreme Court decision. I'm talking about the beautiful report by the commission. We can't wait to see it come out. Anybody who's here today, we have your email list, your email address. We will send it to you, and you can send it to your friends. It's another good read, I think. If there's anything like its final draft, it should be quite wonderful. Thank you for those of you who are watching. If you want to learn more or take action, Natasha gave you some ideas. Please look for the email that will follow this webinar from DPF with some ideas. Sign up for our list, and we'll keep you in touch with the things that are going on in California. We hope that the final report will be out today, but it isn't so soon. We hope you will join us for the rest of our series, including the webinar next Wednesday, November 3rd at 4 Pacific time, Why Victims' Family Members Oppose the Death Penalty. Again, thank you all for being here. Thank you especially to Mike, to Rick, to Natasha. Thank you, Mary Kate. And we'll see you all soon. Take care. Onward.
Thank you. Thank you,
Thanks,
Mary Kate.
everyone.
Maddie.
Bye.